Mr. Chairman, members of the committee, for the record, my name is Aubyn Curtiss, and it feels a little strange to be here instead of up here. It's good to see friends again. I'd just like to remind folks that during my 24 years in the legislature, I established a record of standing up for the people on the land, conservation districts, irrigators, everyone engaged in agriculture. So it's strange for me to be standing up here in opposition to folks like former Senator Grossfield and others. Thank you for this opportunity. I've served 24 years in the legislature for Lincoln County, which is where Chaz Vincent is representing us now. So I have to apologize to Chaz for standing up in opposition to his legislation. I have to speak in opposition to Senate Bill 262. This compact flies in the face of Article 9 of Montana's Constitution, and its adoption, in my mind, would render our Montana Water Court a paper tiger. It exempts the Kootenai-Salish tribes from compliance with the same terms of Montana's adjudication process as other water users. When we passed that bill in 1979, which set up the adjudication system, we were operating under federal mandates. We had to tell how much water is Montana. That's the quantification issue. Who was putting it to a beneficial use and where? And I just, in all honesty, I think that this compact should have "Trust Us" stamped across page after page in the extensive document. Trust us that this is good for Montana. Trust us that it will save litigation. Trust us that senior water rights will be protected. Trust us, farmers and ranchers believe this is good for them. Trust us that waiver of the quantification requirement under the adjudication system is acceptable in water courts down the road. Trust us. Grant immunity from liability to those engaged in the process. That is a biggie. Trust us and either vote up or down, but no amendments. That's our understanding right now. What a farce. Why then conduct a hearing such as this if legislators are unable, after deliberation, to determine any changes or clarifications? Can it be that the only place where Montana's Constitution is cited in these hundreds of pages is where authorization for granting the $55 million of state dollars to the tribes is mentioned? You might check that. This compact is vastly different from compacts negotiated with the 6 other tribes. It is precedent-setting in that, I lost my place. It does extend outside the boundaries of the reservations. In other compacts, non-Indians dwelling on the reservations were treated the same as other citizens of Montana. Not so in this proposed agreement. Proponents claim that equal protection under the law concerns are not legitimate ones, but the facts remain. Not one of the other compacts sets up a unitary management authority. Not one gives that kind of entity authority to control allocation of water involving generation produced at 4 hydroelectric dams. We are told that time immemorial is mentioned 11 times in the documents where referencing tribal water rights. But we understand that term is based on folklore and has not been recognized in the court cases applicable to this situation. But it would cede headwaters rights to the tribes, which would put downstream water uses at their discretion. Instead of saving litigation claimed by proponents, this would result in hundreds of water users' rights placed at risk in a position of having to file actions to defend those rights. We know that the U.S. Justice Department would provide counsel to the tribes, but what of the hapless Montanans who have complied with all Montana water laws and by provisions of this compact, yet see their water rights literally sold down the river? Instead of eliminating litigation, this compact will necessitate more. It just depends on who pays and who can afford to pay. Thank you.